This Law Shelf's case study will cover United States v. Yusuf, which is a United States District Court case for the District of Utah. This case was decided in 2021, and it is a criminal case, ultimately, at its core, where the defendant raised a number of issues pertaining to the Fourth Amendment prohibition against unreasonable search and seizure. And so those ultimately are the issues that the case does explore, and we will be covering today. Some of the background of this case involves the fact that it was a cybersecurity investigation, cybercrimes investigation, that was ongoing for several years. During the course of this investigation, state and federal agents were looking at an email impersonation scheme that was allegedly defrauding businesses in Utah. During the course of the investigation, there were a number of names that came up of interested parties. One of these was Venetia Mathis, who was Yusuf's girlfriend. Saeed Yusuf, who actually had a number of AKAs as well, but Mr. Yusuf's girlfriend, Ms. Mathis, was interviewed in a field interview by investigators. And during this interview, she provided a number of pieces of information. She told investigators that she'd seen Yusuf with multiple cell phones, laptops, stacks of bank cards, paperwork in the names of other people. In fact, she, as part of the interview, discussed that he had provided her with a passport and a debit card with somebody else's name. He had coached her into setting up accounts. There was a wide variety of information that was provided. She was coached to setting up accounts for fake companies, and he had allegedly coached her into committing other pieces of fraud or other crimes as well. Ultimately, the information was all taken to grand jury, and Yusuf was indicted and charged with various fraud crimes. Allegedly, the crux of these were that he had used emails impersonating other people to direct employees of the companies that were the victims, the companies that were defrauded, to wire money to these accounts that were ultimately under Yusuf's control. Once he had been charged, a warrant was issued for his arrest. Much of the evidence that was obtained that was later at issue here in this particular case that the court looked at was obtained at the time of the execution of the arrest warrant. So when Yusuf was actually arrested. When they had the warrant, federal agents appeared at his home. They arrived at his home early, I think 0600, something along those lines, first thing in the morning. And they knocked on the door. They asked the residents to exit. A number of people exited the home. A person that exited the home did confirm that he was in fact inside. Now, all of these individual facts may seem to be somewhat random, but these all come together in what was ultimately the court's determination of how the arrest warrant was executed, how the search was executed, and what evidence was obtained, and what evidence was ultimately going to be permissible at trial, or what evidence ultimately was going to be suppressed or not admissible at trial. So when the agents arrived at the home, they did a knock. A number of people exited. One of those people, at least one of them, did confirm that he was in fact in the home. Before they entered the home, the agents also called out. They asked him to exit the home. He did not, and so they entered the house. When they entered the house, when the agents went in, they saw things. You don't walk into a home or walk into any enclosure with blinders on, or keep your eyes closed. Obviously, as part of the entrance of the home, they were looking around to ensure safety and to see what and who was present in the home. And they saw two laptops that were in plain view on a table. This is important because these were things that they just saw in plain view. They weren't hidden. They weren't digging through anything to find them. They weren't pulling them out of drawers. They were just there out on the table. They found Yusuf in his bedroom, or in a bed, and they found him with 3 mobile devices next to him. And the full facts of the case will provide that actually the covers or the blanket, when it came up, showed that there were 3 mobile devices, 3 phones next to him there. When they brought him out of the room, he was given a shirt to wear. He identified that there was a shirt that was his. And as the agents handed it to him, they noticed there were papers that had social security numbers, dates of birth, other identifying information of people who were not residents of that particular home. So that was something that the agents saw as they handed him a shirt that he identified as his own shirt. At this point, it's important to note that Yusuf was handcuffed. He was under the control of the agents. He had actually been handcuffed in the bedroom while he was in the bed. Now, the agents did seize most of these devices, but they specifically did not seize, they did not take certain items. They did not take one of the laptops that was in the residence because it was a laptop that Yusuf indicated was not his laptop. He specifically identified that one was not. So the implication then potentially could be that the others were, but that was one that he indicated was not his. There was also a 4th mobile device that was found apart from where Yusuf was found. That mobile device was not seized. Now, it's important to note that at the time Yusuf was arrested, and at the time that the agents identified these laptops, these mobile devices, and took them into custody as potentially as evidence, when they took Yusuf into custody, they had a warrant for his arrest, but they didn't have a specific search warrant. So once they had obtained this information, once they had arrested Yusuf, they obtained, with the assistance of the prosecutor, a search warrant. They applied for a search warrant. So based on the previously obtained information and the evidence that was seized during the search, they then obtained a search warrant for Yusuf's phone so that they could examine and investigate the materials that they found on his phone. Ultimately, this search of his phone, after they'd obtained it, yielded information about further transactions that pertain to the allegedly illegal conduct that had been occurring, these cyber crimes and frauds that had been occurring over this period of time. Further investigation then ultimately linked accounts that were associated with Yusuf to other accounts that were tied to his phone number, address, associates, all of these connections that were linking everything together. Now, originally, field investigators had obtained a large amount of information from Mathis about the particulars, and that had ultimately led to materials that led to Yusuf being charged in the arrest warrant. They did have a follow-up interview with Ms. Mathis, and she did change her story a bit. So in the original interview, she indicated that all of her contacts, for the most part, with Yusuf had been through Facebook Messenger. And ultimately, she received, prior to the arrest, in the March or April prior to the arrest, she had received a threatening message from him. In the second interview, she indicated that that was through a phone call, that there had been a phone call. So that story did change a bit. And so investigators then paused their search of Yusuf's devices, and then they applied for and obtained an entirely new search warrant for the devices. And then after they'd obtained that, then they continued the search. Yusuf filed a motion to suppress, or his attorneys filed on his behalf a motion to suppress a number of pieces of evidence that were obtained. And the grounds for this motion to suppress, a motion to keep this evidence out, a motion to keep the prosecution from being able to use this evidence against Yusuf, against the defendant, were first, that the devices were seized illegally on the morning of the arrest because the agents didn't have a search warrant. Now, you remember that Yusuf was indicted. He was charged with crimes, and there was an arrest warrant, but there was not specifically a search warrant to search the property or a particular part of the property. So there was a warrant for his arrest, and this becomes important in this case. The search warrant that was later obtained, that was later issued, was not, according to the defense, sufficiently particular about places to be searched and things to be seized if they were located. The Fourth Amendment does require particularity about what is to be searched, what areas are to be searched, and what is to be seized. And we'll look closer at those requirements as the case evaluates those, as the court evaluates them in response to both the defendant's arguments as well as the government's responses. Now, federal agents did testify that the devices that they saw during the arrest raid were consistent with the array of devices that were typically used in this type of fraudulent activity, this type of cyber fraud where companies were being defrauded to divert funds to accounts that were under the control of the perpetrator and not who the perpetrator claimed to be. So what are the applicable standards? The Fourth Amendment protects the public from unreasonable search and seizure from law enforcement. Authorities, before searching and investigating physically and obtaining evidence to use against you in a crime potentially, first have to get a warrant. And they have to get a warrant that's based on probable cause, a reason to conduct a lawful search or seizure. And the standard, how much of a reason, how much information they need to have first, is probable cause, unless one of the exceptions to the warrant requirement applies. So the general rule is that the public is protected from unreasonable searches and seizures. In order to search and potentially seize evidence, authorities first have to get a warrant, unless there is an exception to the warrant requirement. Okay, so that's the structure of this. Now, if evidence is seized in violation of the Fourth Amendment, then it's precluded from admission under the exclusionary rule. That means you can't use it against the defendant. That means it doesn't exist for purposes of proving your case against the alleged perpetrator of the crime. Now, this actually extends even further. So not only is evidence that was seized, if it was in violation of the Fourth Amendment, not permitted to be used, but anything that is derivative of this, if that evidence led you to other evidence that was then obtained properly, if you then went and obtained a warrant, but the information to get you to that warrant and get you to that other information came from evidence that is excluded, that is going to be suppressed, then you can't use that later discovered evidence either. The analogy for this is that it is fruit of the poisonous tree. If the evidence that was later obtained was obtained because of information that you shouldn't have had in the first place, then it's fruit of the poisonous tree. If you can't use the tree, you can't use the fruit from that tree either. So you're just stopped, full stop. Now, the defendant has the burden of proving that a Fourth Amendment violation does exist. It's their burden to prove this. But without a warrant, if there was a search and seizure without a warrant, the government has to prove that there is an exception to the default rule that there be a warrant. So they have the burden of proving an exception to the warrant requirement applies. So what are the potential exceptions to the warrant requirement? Well, there are a lot. There are many exceptions and caveats to the warrant requirement. These include the fact that the warrant requirement only applies to places in the first place that have a reasonable expectation of privacy. So if you're somewhere where there would not be a reasonable expectation of privacy, there is no requirement that there be a warrant. So only where you would be expecting that you would have some sort of privacy in your person or materials or property is where a warrant would first of all be required. Assuming a warrant would be required, there are, again, a number of exceptions, so many A number that are just not applicable here, in fact, in this case, include, for example, if you consent to be searched, there's no need to get a warrant. If you're in an automobile, there are specific exceptions that pertain to the parameters of being in an automobile and what portions of the automobile, for example, what might be within arm's reach, would be within an area that would be searchable if you were, say, pulled over, even if there's no warrant. Exigent circumstances, if the circumstances are such an emergency, if they're so emergent that there's no time to get a warrant and the potential ramifications would be large or significant, then there may be an exception that applies there. But there are two particular exceptions that the government asserted applied here in this particular case, and that the defendant specifically addressed that these exceptions should not apply, and therefore, again, the evidence that was obtained should be suppressed. The exceptions that we're particularly looking at here and what the court considered were the exceptions involving a search that's incident to a lawful arrest, as well as the exception for evidence that's obtained in plain view. So the first exception we're going to look at in more detail is the exception to the warrant requirement, where there is a search that is incident to a lawful arrest, a search that occurs at the time of an arrest that was a lawful arrest. So this exception allows an officer that is effecting an arrest, that is arresting somebody, to search the arrestee's person, so their actual person, their body and what's on them, and areas within their immediate control. And the idea here is that they're doing so to remove any weapons or any evidence that could be immediately destroyed. For example, if somebody's being arrested, an officer would likely pat them down and go over their person to see if they had, a knife in their pocket or a firearm or something that could be used as a weapon. And they may come across evidence or something that ultimately ends up being evidence in the course of that. But they're doing so during the arrest because that's on their person and that would be dangerous. Or, for example, if there's something within their immediate control, if they could reach out and grab something and destroy evidence potentially, eat a bag of drugs so that the evidence is disposed of and no longer available, that would be something that would be part of a search incident to a lawful arrest, so long as the person who's being arrested was being arrested lawfully. And this exception, again, is justified because there is a concern for, first of all, officer safety. And so we don't want, during the course of an arrest, to prohibit an officer from making sure that the person is secured so that they can't strike out with weapons or anything of the like and cause more harm. And also, we don't want somebody to be concealing evidence while it's still within their control while they're in the midst of an arrest. So the immediate rationale for this is that at the time of the arrest, while it's going on, an officer can conduct a search for both safety and evidence protection to basically maintain the scene, whether that scene is the person in their immediate vicinity, while that is happening. Now, once that immediate rationale has passed, officers cannot then continue to avail themselves of this exception. So just because you've been arrested does not mean then that officers can, once the scene and the person are secured, go on and start opening up cabinets and pulling out materials and finding potentially other evidence, because the scene has already been secured. Now, the search then has to be made at the time of the arrest, not 10, 15 minutes later when the arrestee has been handcuffed and is secured, isn't in the back of the officer's car. They can't go back in and then start saying, all right, well, we need to make sure there's no other evidence that somebody could destroy, because at this point, the arrestee has been removed from the scene and has been restrained, and so they could not possibly be doing anything. The rationale no longer applies. Yusuf's argument basically extends from that rationale. Yusuf, the defendant here, argued that the search was incident to a lawful arrest, potentially, and under that exception. But even if that exception applied, it did not allow the officers to then seize the electronic devices and documents during the execution of the arrest warrant. They didn't have a search warrant, they had an arrest warrant. So this was broken down into the different types of devices. Regarding the devices that were found on the bed with Yusuf, remember when the blanket came up, there were 3 mobile devices that were there. When the officers placed them on the ground and handcuffed him, the devices were then beyond his reach. And so, according to Yusuf, they could not rely on the search incident to a lawful arrest to then confiscate those items, to then take those items into evidence, because he could no longer reach them. He was handcuffed in the bed. The documents and the other items that were in the house, according to Yusuf, when he passed through the house, he had already been handcuffed. He was handcuffed in the bedroom. He was handcuffed in the bed. And since he was unable to reach for anything, the rationale behind the search incident to a lawful arrest no longer applied, because the rationale was that it was to protect the officers from further danger by ensuring there were no weapons. He was already handcuffed. His person had been searched. There were no weapons that he could reach for, and he could not reach to destroy other evidence, again, because he was handcuffed at that point. So he was arguing that this was more akin to him being already secured and the officers going back in and then starting a new search, and therefore it was not part of the search incident to a lawful arrest. Again, specifically, a lot of the evidence that was seized, the laptop computers, the paperwork that was seen, the mobile devices, when they were actually bagged up and taken, Yusuf was already outside the house. And in any case, according to the defense, any possible threat from him as far as physical danger or even destruction of evidence at that point had long since passed. It just wasn't there anymore. Now, the court's analysis, and you notice that we don't have the government's argument here because the court actually adopted the defendant's argument here regarding the search incident to a lawful arrest issue, and then focused on the other exceptions. So with respect to Yusuf's argument, the court did agree with that and indicated that if there is no possibility that an arrestee could reach into the area that law enforcement officers seek to search, both justifications for the search incident to arrest exception are absent, and the rule does not apply. So Yusuf was handcuffed in the bedroom and he was escorted. And whatever there was around him, because he was restrained and escorted as he was under these facts, he could not possibly have reached any of the contraband or any possible weapons. And so, as such, this particular exception did not validate the seizure of all the items that were seized. Now, that brings us to the second exception that's applicable here, the plain view exception. So the plain view exception here, the plain view exception to the requirement that there be a warrant, is what actually did a lot of the work under these facts in particular. So the plain view doctrine basically lays out the following requirements: that evidence may be seized without a warrant, again, because our default rule is that law enforcement needs to have a warrant, a valid warrant. But if they don't have a warrant, they need to have an exception that provides for the seizure, the search and seizure of that ultimate evidence. The plain view doctrine indicates that evidence may be seized without a warrant as an exception if 2 factors. First, the officer was lawfully in a position from which the object seized was in plain view. And second, that the object's incriminating nature was immediately apparent. For example, there was probable cause to believe it was evidence of a crime. And 3, technically, the officer had a lawful right of access to the object. So essentially, as long as the officer was legitimately there in the first place, if he could see that evidence from wherever they were, and it was in plain view, it wasn't hidden, it wasn't in a drawer, it wasn't behind a wall, it wasn't in a safe, it wasn't buried under the floor. If he could just see it out there in plain view, then it would likely fall into the plain view doctrine. So you could also have a situation where the officer didn't need any justification to get there in the first place. For example, let's say the officer is on a public street and looks over and can see contraband from where he's standing and is legitimately out in public. In that case, he may not need any additional justification because he can see it from the place that he's legitimately able to be. Or it might be that we're in a situation where the officer had the right to enter. For example, he had the right to enter and execute a lawful arrest warrant. Ding, ding, ding. Does this sound applicable to the case at present? Yes, it does, because again, the officers had the right to lawfully arrest Yusuf in this situation, and so they had the right to enter to do so. What were Yusuf's arguments? What were the defense's arguments here against the plain view doctrine? Well, ultimately, Yusuf argued that the first and third elements of the plain view exception were not met. Why? Because he argued the agents exceeded the scope of a search incident to arrest. So again, linking to that prior exception and those arguments. Once he was arrested, once he was cuffed and out of the home, according to the defense, they were no longer lawfully in the home. Officers were no longer lawfully able to be there because their lawful presence in the home, once he was arrested, was done. They were lawfully able to be in the home only so long as it took to effectuate the arrest warrant, and then they were done. The timer dinged, they had to get out. At that point, he was unable to access any weapons if he was going to resist escape. He was unable to access any evidence that he could potentially destroy, and he'd already been removed from the residence, and so they'd already used up their valid reason for being there to arrest him, and there was nothing that they could do any further under the search incident to a lawful arrest. He'd been taken from the home, he was secured in a vehicle, and at the time that they were taking into custody these items, he was fully restrained in the vehicle. And at that time, his argument is that the agents were not permitted to remain in the home after he was arrested and secured without also having a search warrant. He also argues that the second element was not met. The second element, remember that the items on their face appear to be incriminating or have something to do with the crime. It says that the second element's not met because the incriminating nature of the items was not immediately apparent. These were just mobile devices, a couple cell phones. Cell phones don't look ominous. Cell phones don't have signs on them that say, I am incriminating, I'm used for illegal things. They're just cell phones. They're neither good nor bad, they just are. So it's not obvious they would be incriminating just by looking at them, as opposed to, say, a bag of drugs or a bloody knife. Those, when you look at them, they kind of scream incriminating on their face. So the government basically advanced three arguments here. They advanced three arguments that were relevant to the first and third prong of the test. Now, for organizational purposes, the court actually addresses the arguments pertaining to the first and third prong of the test here, and then they go back and address the second. So we're following that analysis as well here. The first argument that the government made was that the general restrictions on searches incident to a lawful arrest, on which Yusuf is relying to establish the limits of the agent's conduct, apply only to searches. So they don't apply to seizure of items that have already been searched, items that are already discovered during the search. So the fact that Yusuf was secured in the vehicle, the police vehicle, and had been handcuffed, does not undo the fact that these items were already searched. They'd already been seen by the agents. You can't unsee them. It was just a matter of then bagging them and taking them into custody. So the limitations that Yusuf or the defense is relying on apply to the search itself. They didn't go back and now look where they had walked through with their eyes closed before. They just went in to go and catalog the things that they had already seen. The search was complete when the agents had seen the items. And neither observing nor seizing an item that is in plain view is in fact a search. That was another argument. There was no searching here. These items were all in plain view. So once the devices were exposed and the agents saw them without looking for them, they're just there. They can't not see them. It didn't matter whether the defendant was in handcuffs or not. They're all sitting there in front of the agents. They can see them already. They're in plain view. Nobody is even lifting something or moving something that was obscuring there. They're just sitting there. There's laptops on a table. There's mobile devices that are sitting there on the bed. Again, when Yusuf was first arrested, he was under the cover, and to arrest him, the cover was lifted and those mobile devices were there with him on the bed. Third, the government's argument, an arrest warrant inherently authorizes that you have to go into a place, and it's actually much broader than a search incident to a lawful arrest. So this idea that the agents were not permitted to be there except to basically levitate through to the bedroom where Yusuf was and somehow magically portal him out without entering into the place where he was to arrest him is a little silly, is a little strange. You have to enter into the place where the arrestee is to arrest them. It's the nature of what you do, and it's actually much broader than a search incident to a lawful arrest. The agent's authority to enter the defendant's home came from the arrest warrant. So their continued presence in the home once he was handcuffed was governed by the arrest warrant authority, and it wasn't limited to the parameters of that first exception that Yusuf was relying on and saying they couldn't meet the search incident to a lawful arrest. Now, the second factor was addressed separately. The second factor for a plain view doctrine exception is that the incriminating character of the material must be immediately apparent. So the defendant's argument was this. First, there was no indication the devices observed and seized had been used in the charged offense that occurred 2 years earlier. Second, the information from Mathis, his girlfriend, about Yusuf's use of multiple cell phones and computers was 4 years old. And third, that due to the prevalence of computers and cell phones in society today, the fact that a cell phone is there does not show any suspicious activity, even the fact that there might be several cell phones. In today's society, many people have multiple devices, and that is not immediate appearance of illegal activity or even something suspicious. Now, the court agreed with the government ultimately, and they determined the second factor was satisfied because where agents acted on information that electronic communications were used to further crime, seizing electronic means to make those communications is reasonable. This was a crime of cyber fraud, which was alleged to include using those specific types of mobile devices and laptop computers, and that those electronic communications were made from devices just like that. And so it was reasonable to connect those electronic means to the crime itself. And given the ongoing nature of Yusuf's conduct, this was an investigation that spanned several years, and his continuing reliance on electronic communications and internet use, that was the nature of what he was charged with. The fact that there was an enduring nature of electronic storage, you can find materials electronically for more than just the last day, the last hour, even applications that I'm not as familiar with them personally, but there are applications where things disappear after a certain amount of time. Even those kinds of things leave traces, I imagine, that can be discoverable. So there's evidence of those kinds of materials in electronic storage. It's immaterial that evidence supporting the charged offense and the officer's probable cause may have been up to 4 years old. It still very likely could have been on those devices. Phones and laptops store activity that's gone on for a long time. If you've been using a laptop for 10 years, it's likely that it has stored activity for those 10 years. So just because it may have then also had information that's more recent does not undermine the fact that that information from 4 years ago would have been on there. Now, on factors 1 and 3, the court essentially just adopted the government's arguments. They agreed with those, and then they found that the second factor was satisfied for these reasons. So ultimately, the plain view doctrine did apply here. The agents, when they are lawfully on private property, have lawful access to those parts of the property where their presence is authorized. And then the materials or ultimately evidence that is in plain view, if it meets the requirements, and here the second factor was satisfied here, that it did meet the requirements under these facts, then the plain view exception applies, and these searches and seizures were in fact legal. Another of the defense arguments for the exclusion of this evidence that was obtained involved the particularity of the warrant. So remember that the Fourth Amendment prohibits search and seizure without a warrant unless there's a particular exception. And the specific language of the Fourth Amendment is that the warrant must be issued particularly describing the place to be searched and the persons or things to be seized. You need to be specific. This is not a free-for-all. Just because you've gotten a warrant, that warrant cannot be a carte blanche to open somebody's life. The search has to be carefully tailored to its justification and not become the wide-ranging exploratory search. We do not want, consistent with the Fourth Amendment, for authorities to be able to go on a fishing expedition just because they've gotten a warrant. That's not a free-for-all. The test applied to the description of the items to be seized is a practical test. A description is sufficiently particular if it enables the searcher to reasonably ascertain and identify the things authorized to be seized. Is the language specific enough to where the searcher could reasonably identify what they're looking for and what they're supposed to be taking? So a warrant that describes the items to be seized in broad or generic terms may be valid if the description is as specific as the circumstances allow. So it is very fact specific, and it is evaluated and viewed on a case-by-case basis. So Yusuf, the defendant, argued that the particularity requirement was not satisfied, that even when there was in fact a warrant, it was overbroad and the particularity requirement was not met. So Yusuf argued that the search warrant was facially overbroad. The list of references that it gave was too broad to limit the scope of the search, and it thereby gave investigators unfettered discretion in searching Yusuf's electronic devices. So it allowed them to just look at whatever they chose to look at. It also was part of his argument that using the word including in the warrant, because the warrant says that you can identify a number of things, including these particular items, followed by a list of materials to be seized, mobile devices, laptops, etc. That was a catch-all phrase, and that was overly broad. So using the word including made the whole warrant overly broad. Put a pin in this one because the court does specifically address this. The warrant also, according to the defense, failed to include particularized information available to the government at the time the warrant was sought. So they had information. They could have streamlined it further. They had information and did not include it, so it was not particularized. It failed to include information from the supporting affidavit that was more narrow than the warrant, and that would have narrowed the scope of the Georgia warrant to specific transactions, specific entities, or individuals already known to agents. Now, the government responds as follows. So the court agreed with the government on this issue as well. So this is the analysis the court signed on to and what's included in the opinion. So it's not listed separately in your materials, but in reading the case itself, you can see that they adopted this rationale and it adopted this analysis. Ultimately, the court determined that they agreed with the government that the warrant was not facially overbroad because it does include 3 limiting features. The warrant references the particular charging statute. It references a particular statute that the defendant, Yusuf, was charged as violating. Second, the warrant includes a reference to a particular date range for the violations, and it requires that the violations involve particular people. And third, the warrant included a list of the kinds of records that might provide evidence of the violations that were referenced. The including, that term that Yusuf identifies as overly broadening the warrant, was actually a limitation. I know it seems that we're arguing semantics, but we've all seen that language, including but not limited to, and then a list of items. The court goes into a bit of a discussion and evaluation over this language, over these semantics, and using that term including, and not the term including but not limited to, was actually a limitation and not a broadening of the materials. Furthermore, where the phrase including but not limited to is used after the scope has already been defined, when you've already said this is what we're looking for, including but not limited to, that is just providing a list which is also further narrowing the scope of the warrant. So the court makes a determination that this language is not broadening language, but in fact limiting language. In this particular case, the warrant imposed a general restriction on seizable records by requiring they relate to violations of a specific federal statute with additional limiting factors. And so, although including but not limited to is broad language, the limiting features in the warrant are enough to make it not overbroad on its face. Here, the affidavit presented probable cause to believe that Yusuf was working internationally with multiple co-conspirators and using multiple entities to defraud a variety of businesses over a period of years. And so there was reason to believe that the transactions were just part of ongoing activity, and we didn't have all the details of it yet. So in a situation like this, according to the court, the warrant didn't need to be limited of the particulars of only what we already knew, because we reasonably believed that what we already knew were just part of a much bigger ongoing picture. So there was so much activity sustained over a long period of time by Yusuf, and that was referenced by the affidavit itself. So limiting the scope of the search to records of activities and already known transactions is not something the Fourth Amendment requires. And that, in fact, would be unduly limiting on the government to say you can only go to search for evidence of what you already have evidence of, would be unduly limiting. Now, while the court's ultimate ruling, as we've talked about and we'll see, in just a few moments, was to allow the evidence and to find that it did fit into the plain view doctrine, the plain view exception. There was another exception that was potentially applicable, and the court does reference, and both the government raised as well as defense argued against the good faith exception. So there's one further exception that we will talk about to the exclusionary rule. Again, the exclusionary rule being that any evidence that's obtained from an unreasonable search and seizure would be excluded. And so that would be the exclusionary rule. That's the remedy under the Fourth Amendment, is to exclude the evidence if it was not properly obtained. And there is a good faith exception. The exclusionary rule, again, generally prohibits the use in evidence of the products of an illegal search and seizure by the police or by law enforcement. But in addition to the other exceptions that we've talked about, as well as the additional exceptions to the warrant requirement that we're not even addressing here in this case, there is an overall good faith exception, and this was allowed in a 1984 case, Leon v. U.S. The court need not suppress the fruits of a search so long as the executing officer had a good faith belief that the warrant authorizing the search was valid. So if an officer is acting in accordance with a warrant and the officer in good faith believes that the warrant authorizing the search is valid, then the court need not suppress the fruits of that search if it is then ultimately determined that the warrant and the resulting search was not valid. Suppression of evidence obtained pursuant to a warrant should be ordered only if its exclusion will further the purposes, the underlying rationale of the exclusionary rule. So when an officer relies in objective good faith on a warrant, not just that they're sticking their head in the sand and pretending not to see all the warning signs going on around them, but objectively, based on the situation, it appears to all be in order, and they are in good faith relying upon it. If it is later invalidated, there was no police illegality, and thus nothing to deter, because that is what the rule, the exclusionary rule, is doing. It's encouraging the proper action of law enforcement by deterring them from illegally bypassing the limits on searches. It is encouraging them to act appropriately in their searches by going through the appropriate channels, by only searching what they're permitted to search, by not unduly infringing on the citizens' rights, by saying, if you do this, we're not going to let you use that evidence. So we're deterring that conduct. If they're already acting in good faith and objectively everything appears to be legal and valid and they're acting appropriately, excluding the evidence, if it later turns out that there was some sort of defect along the way, will do nothing to deter that conduct we're trying to deter, because that wasn't the issue here. That was not the problem. So how do we determine whether or not there is good faith? Well, to start with, when an officer relies upon a warrant, the officer is acting in good faith. It's only when the executing officer's reliance was wholly unwarranted that there is no good faith. So whether or not a search is valid, if there is a insufficiently particularized warrant, turns on the objective reasonableness of the officer's failure to realize the warrant was defective. Objectively, were they being reasonable? Does the warrant on its face, is it so bad that a reasonable officer would have seen, and did they willfully refuse to see, or were they so far off the mark that a reasonable officer would have seen? And if a reasonable officer would have thought it was valid, then that's acting in good faith. But ultimately, the court has to look at all the circumstances, because this is very fact specific. In this particular situation or in this particular exception, we would be looking at all the facts and circumstances, including the officer's familiarity with the investigation, whether they had been involved in the preparation of the search warrant application itself. What stage of the investigation are we in? And what is the scope of the materials that was seized during the investigation? And how does it relate to the warrant itself? So Yusuf's argument was that there wasn't good faith here. And the basis for that was because, first, he argues the affidavit is more specific than the warrant. So the warrant's based on the affidavit of the officer. The court issues the warrant, making it inherently unreliable to any reasonable officer because the warrant is more broad than what the attesting officer swore to in the affidavit. Second, the searchers, the ones who were there searching the home, were not involved in the initial investigation, and so they had no basis to rely on it. How often is it that that there may be searchers who are involved in a search who have not been involved in every step of the initial investigation? Third, the officers did not seek assurance from the prosecutors that there were no problems with the sufficiency or scope of the warrant. So whether or not it was to be acting in good faith are the officers who are doing the search, in particular, if they have not been involved in the initial investigation, do they need to reach out to the prosecutor at certain steps or at every step of the way or whatever the situation may be to ensure that the warrant was sufficient, the warrant and its scope were sufficient? And the defense is arguing implicitly that they do need to seek assurance and that, in fact, they did not here. And fourth, the warrant here does not describe the manner in which it was to be executed or how the search of the computer databases would be appropriately limited to evidence described in the affidavit. And fifth, that the materials seized from the computer and cell phones were not limited to evidence described in the affidavit. And so ultimately that the government, that law enforcement in this case, did not act in good faith. And the government's response was as follows. First, the affidavit here was broad. It focused on many conspirators, transactions, and accounts. And so it was more reasonable to rely on it for this type of search. So again, the defense argues that the affidavit was not as broad as the warrant. The government says, I'm looking at the affidavit and I think it's very broad. Our argument is that it is very broad and covers a broad span. And so it was reasonable to rely on it. Second, that in fact here, there was an agent who was involved in the case from the very beginning who was actually a part of the search. Now, again, that was one of defendants' arguments that there were searchers who were not involved in the initial investigation. And, not being in law enforcement myself, I can only speculate that it is certainly possible that on every single investigation, you may not have the exact same team appearing on the scene of every single location pertaining to one particular investigation. You may have some changeover in agents. You may have changeovers in personnel. You may have personnel assigned to different locations. So it certainly seems likely to me that you may have searchers who wouldn't have been involved in every single stage of a particular investigation. But in this case, there was an agent who was involved in the case from the beginning, who was there at the search, who was then likely very familiar. The agents, in fact, in this case, did involve prosecutors in the preparation of the warrant application, and the application was prepared largely on information that was provided by the federal prosecutor. So when conflicting information came to light regarding Mathis's story, remember her story changed later along the way from whether or not that threatening message had been sent to her on Facebook Messenger as she had first indicated in an interview, and in her second interview that message had come from Yusuf by telephone. At that time, remember, the agents stopped their search and sought a new warrant based on the new information. And fourth, the government's response, it's not necessary for warrants to contain particularized computer search strategy, but according to the court, it's a folly for a search warrant to attempt to structure the mechanics of a search where Imposing such limits would unduly restrict legitimate search objectives. At the search warrant stage, if you were too detailed as to what could be done and what steps to take, that would be actually restricting any kind of reasonable and legitimate search. And fifth, files that were seized from Yusuf's devices were actually within the scope of the crimes that were described in the affidavit itself, the more narrowly tailored, according to the defense, version of what to look for. So the ultimate result here was that the court allowed the evidence. It did not exclude the evidence, and it ruled that while the seizure of the devices was not necessarily covered by the search incident to a lawful arrest rule, it was covered by the plain view exception to the warrant requirement. While the warrant was not defective, as it sufficiently particularly described the places to be searched and things to be seized, even if it had been, the search and seizure would have still been covered by the good faith exception to the exclusionary rule. And so, as such, the Fourth Amendment does not require the suppression of any of the evidence in this case. All the evidence was admissible and would be admissible potentially then at trial.